You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 99, How to Sign Patent Documents. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. I know what you're thinking. There's no way Adam can do an entire episode about how to sign patent documents. Oh, there's a way, and I'm doing it. Next, you're probably thinking that this episode can't be more than 15 seconds long at the most. Take a pen, sign on the line, scan the documents, and file it with the patent office. Okay, that was probably about 5 seconds. And you think the episode would be over. But guess what? You are in for a treat this episode because there is so much more. The easy way, depending how you want to think about what easy means, is to do what I just said. If there's a form and you have to sign it, you print it out, sign on the line where it says signature, where it says print your name, you print your name, scan it in, upload it to the Patent Office website, and you're done. Now, several years ago, the Patent Office decided that it didn't need what are called original signatures anymore. That's a handwritten signature. That it will accept a typed-in signature called an S signature. And this is where all the problems come in, because I think some examiners truly get joy by rejecting things for stupid technical reasons. So what is an S signature? It sounds simple. You type in your name between 2 forward slashes. So you do a forward slash, your name, and then another forward slash. That's considered your signature. And your typed name below the signature without slashes has to be put below it. I think it's kind of silly for this to be allowed because the whole reason for a signature is you have something that is somewhat unique to the person signing, so you can tell if the person actually signed it. If someone did a document and put it in my name between 2 slashes, and then I say I didn't submit that document, what's the patent office going to say? Well, this is your typed name between two forward slashes, isn't it? And I have to say yes, but what does that prove? It just proves that someone has a keyboard and they typed my name between 2 slashes. It doesn't mean I did it, but the patent office accepts this. So if everyone did an S signature the simple way that I just said it, we'd all be fine. But people try to be creative and fun. Just don't do it. Just be boring and do what I said. The good news is that if you deviate a little bit from what I just said, the patent office will still accept it. Sometimes. If you type in Google S signature rule examples, the first thing that pops up for me is a PDF from the patent office. So take a look at that. I'm only going to go into some of the proper and improper examples they have for inventors and the applicants, not the patent attorney S signature examples. Because if you're a patent attorney, you really should learn how to do this yourself. The federal code that goes into S signature rules is 37 CFR 1.4. And what pops up in this PDF are 13 examples. And it says whether they're proper or not. Then I'm going to give you a pop quiz on whether you think it's allowed or not allowed. And when I say not allowed, what I'm saying is that the patent office considers it like you never signed it, and you'll likely have to do it again. And this is important because if you have a deadline and you need to file a signed document, if it's not signed correctly, it can be treated as if you didn't sign it at all or submit it at all, and then you miss your deadline. So what are some of the examples? Here's the first pop quiz. What if after the first forward slash there's a space, or a space before the second forward slash? Allowed or not allowed? It is, drumroll please, allowed. What if you use a script font as your signature with no slashes? That is not allowed. What if you use a script font, but you include the forward slashes? That is allowed. What if by accident you do your type name above your S signature or to the side of your S signature instead of below your S signature? That is allowed. What if you misspell your name with a typo in either your typed name or the S signature so they don't match? That is allowed. You probably missed that one. Typos are actually okay in signatures. The examiner will probably make a note of it, but the document will be accepted. Okay, next one. What if instead of having 1 forward slash on each side of your printed name, you put in 2 forward slashes? That is not allowed. You think, what's the big deal of putting 1 or 2 forward slashes before or after your name? Well, the patent office thinks it's a big deal. What if you put in your S signature correctly, but then you forgot to type in your name for the printed part of your name, where it says, just printed name, not the signature line? That is not allowed. You think it'd be fine. You have the signature. You could read the name. The name is typed. What's the big deal? Well, it's a big deal to the patent office. You need both the slashes with your name and then your name without the slashes. What if you put in a smiley face or a graphic symbol or a punctuation in your name like an exclamation point? That is not allowed. What if you put in a punctuation mark like an initial in your middle name? So it would be Adam L. Diamond. That is allowed. Now here are some tricky ones. What if you hand wrote your signature, but then you also put in forward slashes, so you kind of mix and match the rules? That is allowed. What if you have a hand signature and you put in 2 slashes before or after your handwritten signature? Remember, if it's typed, that's not allowed, but if it's handwritten and you put in 2 forward slashes before and after, it's actually allowed. Now, patent attorneys have all these rules about where you have to put in your registration number, within slashes, the outside slashes, and whether it's in the signature line or the printed line. So some of the ones I quizzed you on above where it's allowed, if your patent attorney does it, it might not be allowed. All right, so you might think, if it's so simple to just do a typed name between forward slashes, why can't my attorney just do it for me? Basically, it's against Patent Office guidelines for anyone but the person signing to type it in. The only exception is if you're physically not able to type it. Maybe you don't have hands and can't type. If that's the case, the person still has to watch and approve of someone doing it on their behalf. Now, I'm sure all the time attorneys probably do this for their clients. It's just simpler. Because how is anyone going to know who typed it? And while that's true, it's always possible for the Patent Office to request corroborating documentation that the real person did the typing. I think it would be extremely rare and hard that there would be any record of this not being done the right way or someone else typing it in. But it is the rule, and an attorney can be disciplined for doing an S-signature for someone else. And now you think you're done with the signature talk. Think again, because there's more. There are a few situations where the Patent Office isn't going to accept an S-signature. One has to do when a patent attorney has to sign something having to do with enrollment in the Patent Office or disciplinary hearings. Only a real original signature is allowed. You guys won't have to deal with that. It's just a patent attorney rule. One that maybe you'll have to deal with on a rare occasion is if you're faxing something to the Patent Office and you filled out a form for payment by credit card. You have to do an original signature for that credit card payment. You can pay online with your credit card without a signature, but if you're faxing in a credit card payment request form, then you need a handwritten signature. And the last one that you might have to deal with is if you're sending a certified document to the Patent Office and there's a statute that says that it has to be certified. Then you'll need an original signature, a photocopy or a fax of the handwritten signature even on this document won't even be accepted. Now, this most likely happens if you're required to submit a patent application that you filed in a foreign country prior to your U.S. application. And the Patent Office is going to want to see a certified document that this foreign filing actually happened, and they're going to need that patent application. Now, if you can believe it, I didn't even go over all the signature rules, but follow these 2 guidelines. Either simply handwrite your signature and then print your name below it, or put in your typed name between 2 forward slashes, and then below that, type in your name without the forward slashes, and everything should be fine. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.